Okay, hi everyone. I'm Daniel Hubbard from 1 Essex Court. I'm going to speak to you about entire agreement clauses, which doesn't sound like the most exciting topic in the world, but it is an increasingly important topic for two reasons, really. One, because entire agreement clauses have really grown in significance, and whereas they started off as quite narrow types of clause, which would just exclude quite a narrow category of arguments, they've expanded over the last 30 or so years. And so they're now really quite wide and encompass, or rather operate to exclude quite a wide range of arguments that otherwise would be available to the parties. And the second reason they're increasingly important is that the courts have very much in recent years adopted an attitude of upholding these kind of clauses, and where they are upheld, they can have really far-reaching consequences. Okay, so that's a sort of general setting of the scene. So what this topic concerns is the sort of perennial battle between, on the one hand, trying to say that the whole of the parties' agreement is contained within the four corners of the written contract, and on the other hand, trying to say that the parties' rights and obligations can be affected by something which you don't see in the written contract itself. And there are five main ways that a party might seek to change what's there in the written contract. And it's these five things, or one or more of them, that entire agreement clauses are designed to stop, to keep out. And those things are: first, collateral warranties; second, misrepresentation; third, implied terms; fourth, estoppel; and fifth, variation. Now, entire agreement clauses, properly so called, are only really directed at the first of those things, collateral warranties. And we'll see as we go on that other types of clause have developed, things sometimes known as basis clauses, or sometimes described as no reliance or no representation clauses. And those different types of clause are designed to keep out the other things I mentioned. So not the collateral warranties, but the other four bases on which a party might seek to add to or subtract from a written contract. Now, I hope everyone's got the handout which I circulated. If you look at the second paragraph on that handout, starting entire agreement clause, you see a quote there from the Court of Appeal in a recent case called Hipwell against Surek, where they described these different types of clause as juridically different but complementary. And I'm going to use the phrase entire agreement clause as a sort of composite term to refer to each of these different types of clause, and we're going to look at each of them individually. Now, before we do that, there are two big picture points to make. The first is that the courts do take these clauses but very seriously. You'll often find entire agreement provisions in the boilerplate part of the contract. And for that reason, there's a temptation to overlook them, or to not attribute the kind of significance to them that they deserve. And you see that kind of argument was run in a case called Ravanavi, which you'll find at paragraph 3 of the handout. And if you look at the quote from Lord Justice Moore-Bick in that case, where he said, "I'm unable to accept the suggestion in the buyer's skeleton that clauses of this kind can be construed by reference to their supposed purpose, or that their significance is diminished if they're found among what are sometimes called the boilerplate provisions of a formal contract of this kind." So a pretty obvious point, but the court there making clear that just because these provisions are often found at the end of the contract in the sort of bolt-on provisions. That doesn't lessen their significance. And as we'll see, and as I alluded to before, for about the last 30 years, these types of entire agreement clause have been gathering strength, and they really reached their, or at least their current high watermark in two Court of Appeal decisions we're going to look at, the first called PK and the second called Springwell. And as a result of those two decisions, entire agreement clauses are really sort of riding high at the moment. And it's another reason they can't be ignored. Now, the second general point, and it's really the flip side of the first, because these provisions have such a potentially wide-ranging effect, the courts construe them but very carefully, and they examine the language of these clauses carefully. And in the development of this area of the law, that we'll see that there are lots of attempts to exclude rights and obligations by reference to entire agreement clauses, which just fail because the language isn't quite right and the clause doesn't do the job that it was designed to do. But the good news is that because by now there have been a lot of cases about entire agreement clauses, there's a lot of authority out there which explains what rights and obligations, particular entire agreement clauses, are effective to prevent arising. And so because of that authority, it's pretty easy at this stage to be able to identify, in the case of any given entire agreement clause, what rights and obligations it stops, the particular clause stops arising. And there's also a real wealth now of quite high authority discussing these types of clause, which means that the scope for debate about what rights and obligations these clauses exclude is now reasonably narrow. So I mean, that's good news for us as lawyers, because it makes it easier to spot what effect these clauses will have. Okay, so we'll start at the beginning with the most straightforward type of entire agreement clause. And an example of one of those, the sort of vanilla entire agreement clause, appeared in a case called Intrapreneur against East Crown, which is quite an important case in this area of the law. And you can see the particular words of that clause at point 4 of the handout. And you see it was a very straightforward, short clause, which simply read, "This agreement constitutes the entire agreement between the parties." And what the court held in that case was that those sorts of words are effective to prevent a party from contending that some terms of the agreement are to be found outside of the written agreement and not in the written agreement itself. And what the court found in particular is that that type of simple clause we've just looked at is effective to prevent someone arguing that there are any collateral warranties. Now, just to remind ourselves what collateral warranties are, that these are essentially side agreements, that they usually consist of an oral promise by one party, which doesn't make its way into the written agreement, but which becomes binding when the promisee provides consideration by entry into the written agreement itself. So it's sort of side agreement to the main agreement, which becomes effective when the main agreement is entered into. And that type of entire agreement clause we've just looked at in Intrapreneur prevents those collateral agreements or side agreements from arising, and prevents a party from contending that part of the agreement only is contained in the written contract and part of it lies elsewhere. So let's look at what Mr. Justice Lightman said about that type of clause in Intrapreneur. And you see that quote at the top of page 2 of the handout, where he said, "The purpose of an entire agreement clause is to preclude a party to a written agreement from threshing through the undergrowth and finding in the course of negotiations some chance remark or statement on which to found a claim, such as the present, to the existence of a collateral warranty. For such a clause constitutes a binding agreement. He's obviously talking there about the entire agreement clause between the parties, that the full contractual terms are to be found in the document containing the clause and not elsewhere, and that accordingly any promises or assurances made in the course of the negotiations shall have no contractual force, save insofar as they're reflected and given effect in that document. In the final sentence of that quote, he explains juridically how entire agreement clauses work in the case of collateral warranties. He says, the operation of the clause is to denude what would otherwise constitute a collateral warranty of legal effect. So in other words, you're perfectly still able to argue that one party made a promise to you outside of the terms of the written contract. But where you've got an entire agreement clause, then that promise is incapable of taking legal effect because all of the terms are to be found in the written agreement itself. Now, if we just pause there, you might be wondering, in light of the parole evidence rule, why any of this matters, why you need an entire agreement clause, because the so-called parole evidence rule is that where a contract has been reduced to writing, then you can't vary or qualify that written contract by reference to oral evidence. And if that's right, then why do you need an entire agreement clause? Well, the answer to that is that the parole evidence rule, properly understood, only applies if the court first decides that the whole of the parties' agreement is contained in the written agreement. It's often misunderstood, the parole evidence rule. What it doesn't do is to prevent the court, as soon as it sees a written agreement, from looking outside of that written agreement. If the court decides that in a particular case, although there is a written agreement, it only constitutes that written agreement only contains part of the parties' contract, it's perfectly able to look outside of that written agreement in order to find the rest of what the parties agreed. The parole evidence rule, it is something of a red herring, and it isn't effective to prevent a party from relying, for example, on an argument from collateral warranty. And that's why you need entire agreement clauses, because as we've seen from the decision in Entrepreneur, once you've got one of those, then the parties aren't able to argue the agreement's partly contained orally or partly contained somewhere other than the written document itself. Now, you obviously have to, in the case of all contractual provisions, look at the terms of the contract very closely. But in general, courts will find that the sort of simple entire agreement clause appearing in Entrepreneur, it is effective to prevent collateral warranties from arising. And the authority for that is set out at paragraph 5 of the handout, a case called Papanicola against Sandu, where Simon Picking QC said, sitting as a deputy, said, in general, an entire agreement clause is likely to be regarded as precluding reliance on a collateral contract or warranty. And just quickly, at paragraph 6, you find essentially the same thing in more emphatic language from Lord Justice Longmore in a case called Northeastern Properties against Coleman, where he says, if the parties agree the written contract is to be the entire contract, it's no business of the courts to tell them that they don't mean what they've said. So what's the limit of this principle? I mean, we all know that often parties will enter into contracts and they won't be aware of everything that they've agreed and may not appreciate the full consequences of an entire agreement clause, particularly if it's contained in the boilerplate provisions, as they often are. So what happens then? What if it's obvious from the circumstances that the parties didn't intend the written agreement to constitute the whole of their agreement, yet there's an entire agreement clause saying that they did? Well, this question arose quite recently in the case we looked at briefly before, Hipwell against Surrock, where the relevant entire agreement clause, and we can see this on page 3 of the handout at the top. The entire agreement clause there said that the written agreement constitutes the entire agreement and understanding of the parties relating to the transaction. So very similar wording to the clause in intrapreneur, just in slightly longer terms. And at first instance, the court decided that notwithstanding the existence of that clause, the parties' true intentions were so plainly inconsistent with an entire agreement clause, with the entire agreement clause, as to effectively outweigh and oust that clause. So in other words, it was decided at first instance that where it's clear from the circumstances that notwithstanding the entire agreement clause, the parties don't intend the written contract to constitute the whole of their bargain, you can effectively ignore the entire agreement clause. And the judge in that case at first instance relied on an earlier decision in a case called Fulton Motors, where it had been said where the parties could not have intended the form of agreement, including the entire agreement clause, to express the entire agreement between them, then the entire agreement clause doesn't apply. Now, in Hipwell against Surrock, the Court of Appeal rejected that approach, and in so doing, they confined Fulton Motors to its facts. And if you look again at the top of page 3 of the handout, you see a quote from Mr. Justice Hildyard, sitting as a judge of the Court of Appeal in that case. And he said at paragraph 20, the entire agreement provisions under English law would ordinarily be given full force and conclusive effect as an integral part of the parties' bargain in accordance with its terms. So just to sort of summarize where we get to after those cases, it's fair to say that it's pretty much impossible, at least it's very, very difficult to pursue an argument based on a collateral warranty, or to argue that the contract is only partly contained in the written agreement and partly contained elsewhere, where you have an entire agreement clause of the sort we looked at in intrapreneur, and which the court also considered in the Surrock case. So that deals with really the first part of the talk, which is concerned with just very simple entire agreement clauses, essentially saying the whole of the parties' agreement is contained in the written document. So the next question is, what about misrepresentation? Are those sorts of simple entire agreement clauses effective to prevent a party from pursuing a claim in misrepresentation? And the simple answer to that is no. And the authority for that is again intrapreneur. And if you go to paragraph 8 of the handout on page 3, you see that at paragraph 8 of that case, Mr. Justice Lightman said, an entire agreement provision does not preclude a claim in misrepresentation, for the denial of contractual force to a statement cannot affect the status of the statement as a misrepresentation. So what he meant by that is that in misrepresentation, if you bring a claim in misrepresentation, you're not challenging the terms of the written agreement. You're not trying to say, look, the written agreement means something else, or it ought to be added to by this particular provision or this particular oral promise that was made. You're not doing that at all. What you're saying is, I was induced to enter into that written agreement by a false statement made by the other party. So in other words, you're not trying to attack the integrity of the written agreement. And it's for that reason that misrepresentation claims aren't prevented by entire agreement clauses of the type we looked at in intrapreneur. So what that means is that if you want to prevent someone from bringing a claim in misrepresentation. It's not enough simply to say in the contract, this contract represents the entire agreement between the parties. You've got to go further. Now, an attempt to go further, we can see in a case called AXA Sun Life against Campbell, which you'll find at paragraph 9 of the handout on page 3. And the relevant entire agreement clause there was at 24, and you can see it quoted just beneath the citation. It said, "This agreement and the schedules and documents referred to herein constitute the entire agreement and understanding between you and us in relation to the subject matter thereof." So that first part of the entire agreement clause was very similar to what we saw in the Surrett case and in Entrepreneur itself. But in this case, the clause went further, and it said, "Without prejudice to any variation, this agreement shall supersede any prior promises, agreements, representations," obviously the crucial bit, "undertakings or implications, whether made orally or in writing between you and us relating to the subject matter of this agreement." And it was argued in that case that those additional words, particularly the reference to a representation, prevented the parties from to the contract from pursuing a claim in misrepresentation. Now, the Court of Appeal disagreed with that, and you can see the reasons why at paragraph 81 of the judgment of Lord Justice Ricks. And essentially their reasons for disagreeing was they found that the whole of this clause 24 was just concerned with the agreement between the parties. And so when clause 24 refers to representations and representations being superseded by the written agreement, what that meant was that no pre-contractual representations were capable of becoming part of the written contract. What was said in the written contract superseded anything that was said before. But what the Court of Appeal decided this clause wasn't concerned with was misrepresentations. And you see that if you turn over the page, at the top of page 4 of the handout, second line from the top, the court said these are words of agreement, and where the critical single word representations, not misrepresentations, is likely in context to refer to representations which might be argued, but for the clause, to have become terms of the agreement. And so the court decided that even though the clause referred to representations, it wasn't effective to prevent a claim in misrepresentation from being pursued. So what's the lesson you draw from that case? It's a simple lesson. If you want to exclude, or rather prevent a party from pursuing a claim in misrepresentation, you've got to be absolutely clear that that's what you're doing, because the courts will construe entire agreement clauses but very closely. And you get that even more starkly from the next case referred to in the handout at paragraph 10, which is Thomas Witter against TVP Industries, and the statement of Mr. Justice Jacob in that case, which was cited in AXA, and which you'll often see cited in cases on this topic, where his lordship said, if a clause is to have the effect of excluding or reducing remedies for damaging untrue statements, then the party seeking that protection can't be mealy-mouthed in his clause. He must bring it home that he's limiting liability for falsehoods he may have told. So those types of decisions have given rise to something called basis clauses, which is a phrase you'll see a lot in the cases when discussing the effect of entire agreement clauses on claims in misrepresentation. Now, basis clauses are something really distinct from entire agreement clauses, although going back to the earlier quote, that juridically distinct but complementary. Both types of clause are seeking to prevent parties from pursuing remedies on the basis of things not contained in the written agreement. Now, the classic sort of basis clause will say something like, the parties acknowledge or agree that no representations have been made before this contract was entered into, or that in entering into this contract, neither party relies on any representations that might have been made. And that's why they're called basis clauses, because what they're seeking to do is to set out the basis on which the parties have entered into the contract, and they're seeking to record in the contract what happened before the contract, the facts that were there before the contract was entered into. And to give you an example of what we're talking about when we refer to basis clauses, have a look please at paragraph 11 of the handout, still on page 4. And this is a basis clause taken from a case called First Tower Trustees, a recent decision of the Court of Appeal. And the clause in that case said the tenant, it was a leasehold, the tenant acknowledges and agrees that it has not entered into this agreement in reliance on any statement or representation made by or on behalf of the landlord other than those in writing, etc. So that's a classic basis clause. It says that the parties are acknowledging and agreeing that that the tenant in this case hasn't relied on any statement or representation which was made before the contract was entered into. So if we just pause there, we can see that it's quite a radical provision, because it's essentially seeking to deem a certain state of affairs to be true, whether or not it was true. What it's saying is the parties agree that the tenant didn't rely on any pre-contractual representation, even if, as a matter of fact, the tenant did rely on that kind of representation. Now, the problem that those kind of basis clauses faced, at least historically, was a decision of the Court of Appeal from 1960 called Lowe and Lombank, which is authority, or was authority, for the proposition that those types of basis clauses we've just looked at could only operate by way of an estoppel. And I'll explain what I mean by that. Now, the facts in Lowe and Lombank were reasonably straightforward. A claimant bought a second-hand car that was represented to her as being in perfect condition, but in fact, she couldn't drive it. It was totally unroadworthy. But in the contract under which she bought that car, she'd acknowledged and agreed certain pre-contractual facts, putting facts in inverted commas, which it was common ground were fatal to her claim. Now, what the Court of Appeal said in that case is that that type of acknowledgement or agreement in a contract can only operate as an estoppel. So in other words, if you say in a contract that a certain something did or didn't happen, so for example, you say that you haven't relied on any pre-contractual misrepresentations, what that amounts to is a representation to the other party that that fact is true. And that representation can only operate as an estoppel. So in other words, it can only operate if the other party believed that statement to be true and relied on it. And the Court of Appeal said it makes no difference if you say in your contract that someone acknowledges that something did or didn't happen, or if you describe it as an agreement that something did or didn't happen. And we'll look at what Mr. Justice Diplock, the way that Mr. Justice Diplock put it in Lowe and Lombank, and you'll find the relevant quote at page 5 of the handout at the top. So he said, to call it an agreement as well as an acknowledgement by the plaintiff can't convert a statement as to past facts known by both parties to be untrue into a contractual obligation, which is essentially a promise by the promisor to the promisee that acts will be done in the future, or that facts exist at the time of the promise or will exist in the future. To say that the hirer agrees that he has not done something in the past means no more than that the hirer, at the request of the owner, represents that he has not done that thing in the past. And this is the really important part of the quote. If intended by the hirer to be acted upon by the person to whom the representation is made, believed to be true by such person, and acted upon by such person to his detriment, it can give rise to an estoppel. It can't give rise to any positive contractual obligation. So if we apply that analysis to the clause we looked at a moment ago in First Tower Trustees, so go back please to paragraph 11 on page 4. So that the way that you'd have to deal with this clause in light of Low and Lombank is that the acknowledgement by the tenant that he's not entered into the agreement in reliance on any statement or representation, it self-operates, that statement in the contract, it self-operates as a representation by the tenant to the landlord that the tenant hasn't relied on any statement by the landlord before the lease was signed. And the tenant's only stopped from resiling from that representation that he hasn't relied on any statement by the landlord if, among other things, the landlord can show that he believed that representation by the tenant both to be true and further was induced to enter into the lease because he believed that statement to be true. And it's obvious that it's very difficult, or in lots of cases it will be very difficult for a representee to prove those things, because often the person who makes the pre-contractual statement will know that the other party relied on that statement, and so won't be able to prove that he believed the representation that no representations had been relied on to have been true. And just to sort of summarize that, if we look at page 5 of the handout and point 13, the case of Waterford Electronics against Sanderson, where Lord Justice Chadwick said what the acknowledgement seeks to do, and he's speaking there about the type of acknowledgement that we just looked at in the extract from the lease in First Tower Trustees. What the acknowledgement seeks to do is to prevent the person to whom the representation was made from asserting that he relied upon it. If it's to have that effect, it will be necessary for the party who seeks to set up the acknowledgement as an evidential estoppel to plead and prove the 3 requirements identified by this court in Low and Lombank, which we looked at a moment ago, are satisfied. That may present insuperable difficulties, not least because it may be impossible for a party who has made representations which he intended should be relied upon to satisfy the court that he entered into the contract in the belief that a statement by the other party that he'd not relied upon those representations was true. So if you apply the law in Low and Lombank, the net effect really is that basis clauses were pretty much, they didn't do anything. They weren't effective in the general run of case. They wouldn't have been effective to have prevented a party from bringing a claim in misrepresentation, because the other party would generally not have been able to prove that he believed the representation that in entering into the contract, the claimant hadn't relied on any pre-contractual representations to have been true. So just in very simple terms, on the basis of Low and Lombank, basis clauses didn't have much prospect of success. But that was the old law. Now, very recently, in the 2 Court of Appeal decisions that I alluded to before, that this area of law has essentially been rewritten, and it's been rewritten in a way that's somewhat controversial. There's some academic commentary criticising these 2 decisions, but certainly those decisions represent the current state of the law, and until the Supreme Court decides otherwise, that's the way that the law is. And I'm going to explain what it is, and it certainly makes our life easier because, and we'll look at the quotes, laws A, settled, and B, pretty simple to apply. And the upshot of that change in the law is that parties can now agree that certain facts form the basis of their contract, even if those facts were untrue, and even if they both know that they were untrue, without having to satisfy the sort of estoppel-based arguments that we've just looked at from, or that we've just looked at that the court set out in Low and Lombank. So the two recent Court of Appeal decisions, first, PK, decided in 2006, and second, a case called Springwell, decided in 2010. Now, the facts of these cases were very similar. In PK, there was an investment vehicle which acted for wealthy Dubai investors. In Springwell, there was an investment vehicle which acted for wealthy Greek investors. Now, both of those vehicles invested through merchant banks in financial products issued by the Russian government called GKOs. The Russian government defaulted on those investments, and the investors in both cases lost very large sums of money, and both brought large claims against the banks who had advised them based on misrepresentation. Now, in both of those cases, the banks relied on basis clauses, the gist of which was that no pre-contractual representations had in fact been made by the banks or relied on by the investors. And in both cases, the courts upheld those clauses and decided that they created contractual estoppels which prevented the investors claiming to have relied on any pre-contractual representations. Now, it's important to note that this isn't the kind of estoppel that we looked at in Low and Lombank, the traditional kind of estoppel where you have to establish that a representation was clear, that it was relied on by the representee to that party's detriment, and it would be unconscionable to allow the other party to resile from that representation, etc. That's the traditional form of estoppel. What the Court of Appeal was establishing in these two recent cases, PK and Springwell, was an entirely new form of estoppel called contractual estoppel, which means, in very simple terms, that if you agree something to be a fact in the contract, you're stopped from contending otherwise. So in other words, those decisions sweep away the complications of Low and Lombank that we looked at. And what they say is that if, for example, you say in a contract, we agree that neither party has made any pre-contractual representations, and or we agree that neither party has relied on any pre-contractual representations, then you will be stopped from, either party will be stopped subsequently from pursuing a claim in misrepresentation, because of course two of the essential ingredients of claims in misrepresentation are A, that a representation has been made, and B, that it's been relied on. And that's all that contractual estoppel means. It's a very straightforward concept. It just means that where you've agreed that something, where you've agreed in the contract something was the case, you're contractually stopped from arguing in the future that that thing was not, in fact, the case. And it doesn't matter what the truth was. It doesn't matter if, in fact, representations had been made, if, in fact, someone had relied on those representations. Neither does it matter if both parties know that what's been acknowledged in the contract to be true wasn't, in fact, true. So let's just look at what the court actually decided in PK. And this is probably the most important quote I'm going to ask you to look at in this talk, and you'll find it on page 6 of the handout. It's from the judgment of Lord Justice Morbick, and he says at paragraph 56, there's no reason in principle why parties to a contract shouldn't agree that a certain state of affairs should form the basis for the transaction, whether it be the case or not. For example, it may be desirable to settle a disagreement as to an existing state of affairs in order to establish a clear basis for the contract itself and its subsequent performance. Where parties express an agreement of that kind in a contractual document, neither can subsequently deny the existence of the facts and matters upon which they've agreed, at least so far as concerns those aspects of their relationship to which the agreement was directed. The contract itself gives rise to an estoppel. So that is what contractual estoppel is. It's simply an agreement in a contract that something was the case, which you will subsequently be prevented from residing from or trying to contradict in a subsequent claim. Now, that's a pretty clear statement, the one we've just looked at from Morbic in PK. That the slight difficulty with it was that the court in that case had already, Court of Appeal in that case had already decided that the claim would have to fail, even apart from the existence of the basis clause. So in other words, the quote we've just looked at there was obiter. The other problem with that case is that decision in Low and Lombank, which what Morbic said was really contrary to, was not cited. So there was an argument that PK was decided per incuriam. Now, both of these points were taken in the next case in the sequence, which is Springwell at point 15 of the handout, another Court of Appeal case, which was, like I said before, very similar facts to PK. Investors say that they've been induced to make a bad investment by a pre-contractual misrepresentation on which they relied, and the bank sets up in defense to that a contractual estoppel, i.e. a clause in the contract saying that we didn't rely, no one did rely on any pre-contractual representations. Now, in Springwell, the court rejected the attacks on PK and essentially restated the law, or stated the law in the same terms as Morbic had stated it in PK. And we see that at paragraph 143 of the judgment of Lord Justice Aikens, who gave the only judgment in that case, where he says, before I examine Low and Lombank and subsequent cases on this issue, I'll try and analyse the matter from principle. And this is the important bit. If A and B enter into a contract, then, unless there is some principle of law or statute to the contrary, they are entitled to agree what they like. Unless Low and Lombank is authority to the contrary, there's no legal principle that states that parties can't agree to assume that a certain state of affairs is the case at the time of the contract is concluded, or has been so in the past, even if that is not the case, so that the contract is made upon the basis that the present or past facts are as stated and agreed by the parties. And then he goes on in the next paragraph, about midway down, should it make any difference that both A and B know at, and before making the contract, that A did, in fact, make representations, so that the statement that A has not, the statement that A had not, is contrary to what each side knows is the case. I'm unaware of any legal principle to that effect. And then he goes on to endorse what Morbic said in PK. And then at paragraph 155, just beneath that, he distinguishes Low and Lombank and essentially confines it to its facts. So where we are after all of this is essentially this: Low and Lombank isn't really good law anymore. It's really confined to its facts. And if you have a clause in the contract which sets out the basis on which the parties have contracted, that clause will be upheld. So prima facie, a basis clause of the type that we've looked at will kill a potential claim in misrepresentation. The law is as stated in PK and Springwell, and Low and Lombank is no longer good law. And just to sort of confirm that, if we look at a very recent Court of Appeal decision at the bottom of page 7 of the handout, First Tower Trustees, which we looked at very briefly before, we see Lord Justice Lewison saying at the top of page 8 of the handout, it's now firmly established at this level in the judicial hierarchy that parties can bind themselves by contract to accept a particular state of affairs, even if they know that state of affairs to be untrue. This is a particular form of estoppel which has been given the label contractual estoppel. Unlike most forms of estoppel, it requires no proof of reliance other than entry into the contract itself. So does that mean that where you have a basis clause saying either no pre-contractual representations were made or that no pre-contractual representations were relied on, you can never bring a claim in misrepresentation? Well, it doesn't mean that, because there are a number of exceptions or possible exceptions, and let's quickly go through those. The first of the exceptions is fraud. So in other words, a case of fraudulent misrepresentation. In a case called UBS against Communal, on page 8 of the handout, you see Mr. Justice Mayles recording that UBS accepts the entire agreement and non-reliance clauses on which it relies can't assist it to defeat a claim in fraud, and would only be relevant if any misrepresentation was negligent or innocent. Now that is obviously consistent with the reluctance of the courts ever to allow a case in fraud to be defeated by an exclusion clause or something akin to an exclusion clause. But it's logically difficult to accept the proposition, because if the effect of a basis clause, as the Court of Appeal in Springwell and Piquet said was the effect, to prevent the parties from arguing that any pre-contractual representations have been made or relied on, then it shouldn't logically make a difference as to the nature of the pre-contractual representation. Shouldn't make a difference to that. If you're prevented by a basis clause from arguing that a representation was made at all, why should it matter? Why should the nature of that representation logically matter? You simply can't argue that any type of representation was made. And I think there's logical sense in that, that type of argument was pursued in another recent case called Aquila, which you'll find at point 18 of the handout, and it was rejected by Mrs. Justice Cockerell, who said, this is paragraph 112, insofar as any fraudulent representation is properly pleaded and can arguably be established, it seems to me the portions of the clause relied on by Aquila, which relate to representations, are highly unlikely to bite as a matter of law. The rationale behind this is that a party should not benefit from his fraud. So what she's essentially saying there is, look, forget the logic of the argument. Where you've got a fraudulent misrepresentation, and because a party isn't able to benefit from his fraud, then basis clauses simply won't bite on that contract, and they won't prevent a party from arguing that a fraudulent misrepresentation has been made. But then, in the same case, the judge went on to say something slightly surprising at paragraph 113. She said, I don't see how this affects the position on inducement, even if one ignores the portion of clause 5 which records the parties' agreement that no representations were made. That doesn't delete the remainder of the parties' contractual bargain. What this means is the effect of the remainder of clause 5 on any such representations is to prevent Honour saying that they were induced by any such misrepresentations, and then skip to the final sentence. I would therefore, if necessary, find that the misrepresentation case, even to the extent that it is a proper fraud case, would fail on this head. So what she's saying there is that a basis clause which says no representations have been made can't operate to defeat a claim in fraudulent misrepresentation, but a basis clause that says that the party didn't rely on the fraudulent misrepresentation can operate to defeat a claim in even fraudulent misrepresentation. Now that's a pretty surprising result. Given the first decisions she made at paragraph 112, it's slightly surprising that she went on to decide what she did at paragraph 113, because the upshot is that she's saying that you can, as I read it, she's saying that you can defeat a claim in, or rather prevent a claim in fraudulent misrepresentation being pursued by including a basis clause which says that the parties didn't rely on any misrepresentations, or rather pre-contractual misrepresentations. Now, as to whether that will be followed, and as to whether it will be possible to argue that a claim in fraudulent misrepresentation can be defeated by the type of basis clause that Mrs. Justice Cockerell was speaking about in paragraph 113. I'm really not sure. It seems to me it would be an ambitious argument to make, but given what is said in that case, the door, I think, is open to pursue that kind of argument. Now, the second exception to the idea that the basis clause will prevent a party from pursuing a claim in misrepresentation, except fraudulent misrepresentation, subject to the points we've just discussed, is something that was said in PK by Moore-Bick and was also picked up on in Springwell at first instance, which is that if you have a representation which concerns the meaning and effect of either individual clauses or the entire document, then you can't rely on a basis clause to defeat a claim in misrepresentation based on that kind of representation, i.e. representation as to the meaning or effect of individual clauses or the whole document. Now again, this is a pretty shaky exception. There was no proper analysis in either case as to the basis for this exception or how far it will extend. It's uncertain whether it represents a general exception or something peculiar to the cases in which it was referred to. And I struggle to understand logically why it should be an exception. Again, if you're stopped from contending by a basis clause that any representations were made, surely that includes all representations. Why should representations about the meaning and effect of individual clauses or the entire document be any different? But again, on the basis of what was said by Moore-Bick in PK and Mrs. Justice Gloucester at first instance in Springwell, the door is open to say that basis clauses don't create a contractual estoppel preventing a claim in misrepresentation where the representation relates to the meaning and or effect of individual clauses or the whole agreement. Now, the third of the three exceptions is probably the most important, and that relates to Section 3 of the 1967 Misrepresentation Act. Let's have a look at that. That you'll find the relevant quote at paragraph 19 of the handout on page 9. So Section 3 says, if a contract contains a term which would exclude or restrict A, any liability to which a party to a contract may be subject by reason of any misrepresentation made to him before the contract was made, or B, any remedy available to a party to the contract by reason of such a misrep, then the term shall be of no effect except insofar as it satisfies the requirement of reasonableness. Now, if we go to First Tower Trustees, which is the case just beneath that, and you have a look at what Lord Justice Leggett said at paragraph 90, he articulated an argument made by one of the parties. It's been suggested that in applying Section 3, a distinction should be drawn between an exclusion clause and a so-called basis clause, which does not exclude liability, but by defining the basis on which the parties are contracting, prevents liability from arising in the first place. So the argument there was that Section 3 of the Misrep Act excludes liability for misrepresentation. It therefore doesn't bite on a basis clause, because what a basis clause does is to say either or both that no pre-contractual representations were made, or that if they were, they weren't relied on. So it therefore prevents a claim in misrepresentation from getting off the ground in the first place, because it prevents the parties from establishing one or more of the ingredients of that kind of claims. In other words, it doesn't exclude liability, it prevents liability from arising in the first place, was the argument. But that argument was rejected by the Court of Appeal in First Tower Trustees. And you see that at paragraph 107 of the judgment of Lord Justice Leggett on page 10 of the handout, where he says, if on the facts it's shown that the representation was made and that the defendant would be liable in the absence of the term, and by the term he's talking about the basis clause, then the effect of the term, if valid, is to exclude liability for misrepresentation. It therefore does fall within Section 3. It can make no difference in that regard whether the representation was made and relied on before or after the contract containing the term was made. So where you get to at the end of all of that is that if you have a basis clause saying either no pre-contractual representations were made, or saying that no pre-contractual representations were relied on, that will generally be effective to create a contractual estoppel, preventing either party from subsequently bringing a claim in misrepresentation. The exceptions to that are fraud, although query whether, in light of Aquila, that remains true. Possibly an exception where the representation concerned the nature or effect of the terms of the contract or of the entire contract, although the extent of that exception is very unclear. But in all cases, in answer to a basis clause, you can try to rely on Section 3 of the Misrep Act 1967, and the authority for that is the decision we've just looked at of the Court of Appeal in First Tower Trustees. Now, we basically got to the end of the hour, and I'm afraid I've overran a bit, and I've not been able to deal with the final three topics, which are estoppel, implied terms, and variation. Just very quickly on those. Implied terms, you can exclude, if you use the right language in your contract, you can prevent implied terms from being implied into the contract. Now, a simple kind of entire agreement clause won't have that effect. In other words, a clause of the type we looked at in Intrapreneur that says this document represents the whole of the contract won't prevent terms from being implied, for the simple reason that if a term's implied into a contract, it forms a part of that contract. It forms a part of the written contract. That's what it means to say that a term is implied. And I mean, that pretty obvious point was made by Lord Justice Burnton in the AXA case we looked at before. You see that on page 11 of the handout. He says in paragraph 40, it's the top of page 11 of the handout, paragraph 41, such terms, if otherwise to be implied, are not excluded by the relevant clause in that contract. As intrinsic provisions of the agreement, they are within the expression, this agreement and the schedules and documents referred to herein, which was what the agreement was limited to in the clause in that particular case. But then he goes on, Lord Justice Burnton went on at the bottom of page 11 and just over the page on 12 to say the agreement might have included, but does not include, an express specific exclusion of such implied terms. In other words, he's saying if you get the language right, you can prevent a term from being implied into an agreement. Obviously, that's unless the law prevents that from, some statute prevents that from being the case. Just very quickly, estoppel is probably the most difficult area of the law in this particular connection. There haven't been many cases on entire agreement clauses excluding liability in estoppel, and so there's not the same sort of judicial discussion of the language of those clauses, but and also because there are lots of different kinds of estoppel: proprietary estoppel, promissory estoppel, estoppel by representation, estoppel by convention, etc. And because estoppels often arise during the course of the contract, whereas the things we've been looking at in misrep and entire agreements usually concern, or almost always concern, in fact, things which have been said before the contract has been entered into. It's quite difficult to speak in terms of general language which will be effective to exclude arguments based on estoppel, because most estoppels, you need, in order to establish most estoppels, to establish reliance. If you have a clause in the contract which says, so a kind of basis clause saying that neither party has relied on statements, that may be effective But the difficulty there is that those kind of clauses are usually talking about pre-contractual statements, not statements which have been made during the currency of the contract, which is very often what arguments from estoppel are based on. And you see that in a case which isn't in the list, isn't in the handout rather, called Lloyd against MGL, where an argument from estoppel was attempted, and a basis clause was set up in defense of that. And it was one of the reasons that defense was rejected is that, as the Court of Appeal said in that case, the clause can preclude reliance only on such understandings extraneous to the written contract as had arisen prior to the date of the contract. So just wrapping up on that very quickly, I think probably the most effective way to try to prevent an argument based on estoppel isn't the kind of basis clause that we've been looking at or the entire agreement clause of the type found in intrapreneur. It's really a no variation clause or a no or oral variation clause. In other words, a clause saying that the rights and obligations of the parties can't be changed except by complying with certain formalities, like a written agreement signed by both of them. And that kind of clause ought to be effective to prevent lots of arguments from estoppel arising, because the effect of those kind of arguments is to say that the parties' agreement was changed by some oral representation made by one of them after the contract had been entered into. And that kind of argument ought to be defeated by a no variation clause, assuming, of course, that the formalities haven't been complied with. Very final thing to say, and this is in relation to variation, and this is on the final page of the handout, page 13, a case called, a very recent decision of the Supreme Court called Rock Advertising. Now, this was concerned with the parties agreeing to change their contract after, so it's not talking about estoppel, where a party represents something and the other party relies on it and then says party A is prevented from resigning from that representation. This is concerned with the parties actually putting their heads together and agreeing some change to the contract. And of course, they're generally able to do that. The problem is often that contracts contain a clause saying that certain formalities have to be complied with before a variation can be effective. And the argument against that was, before Rock Advertising, something along the lines of, well, look, the parties are able to decide what they want to decide. And even if their contract contains a no variation clause or a clause saying something like no oral variation, if the parties do purport to orally vary their contract, and even if they've not, before doing so, changed the no oral variation clause in the contract, the fact they've decided to change their contract must at least amount to an implied change of that term or an implied waiver of that term. Now, in this case, Lord Sumption said at paragraph 10, the law should and does give effect to a contractual provision requiring specified formalities to be observed for a variation. And he dealt with the sort of party autonomy argument I've just summarised at paragraph 11 by saying party autonomy operates up to the point when the contract is made, but thereafter only to the extent the contract allows. Nearly all contracts bind the parties to some course of action, and to that extent restrict their autonomy. And then he goes on, and in paragraph 14 he draws the parallel between entire agreement clause, which clauses would prevent a party from relying on a pre-contractual statement, with no oral variation clauses which prevent parties from relying on post-contractual variations, except to the extent they comply with the formalities. The sort of, in a nutshell, what Rock Advertising is saying is that where you have a clause in the contract saying in order to take effect, variations must comply with certain formalities, then the court will uphold those contracts or those terms in the contracts. So sorry, that last part of the lecture in particular was too fast because I ran out of time. but that deals with the main ways in which a party might seek to attack or get round a written agreement, and the types of clauses that are used in order to prevent a party from relying on those types of arguments to get around the written contract. Thank you very much for your time.